Okay, hi there again. Carrying on with assignments. We may finish that today, we'll see. Somebody emailed me and mentioned something that I hadn't mentioned, that they thought I should, and that is on the agreement under the purchasing entity. I talked about having XYZ Limited as trustee, etc. You would normally put and or nominee on the end of that. My belief is that actually from a legal point of view you don't have to put that on in the 8th edition of the sale and purchase agreement. It actually isn't an issue, but agents often like to see it, and so if you want to do it, put it on. So where we got to yesterday was up to, we've now found a buyer. Okay, so when you've got a buyer, you then go to my website again, massiveaction.co.nz, and you click on Investors Library, free downloads, and you scroll down to assignment document, and you click on there, and that will print, and that will give you this, which is a deed of assignment of property. And so you've now got your conditional sale and purchase agreement. I'll do this up here. Okay, you've got your conditional S&P. Just that yields, don't need that. Okay, so you've got your conditional S&P. You've found your buyer. You then are going to fill in the deed of assignment. And this is a document between you and the buyer. This has nothing to do with the vendor of the property. It's a pretty straightforward document. There's no point in trying to show it to you. Go and print it out, and pause this if you need to print it out quickly and then have a look, or you can just click open on screen and it will bring it up on screen. So the very top of this, it's just, you date it. It is between the assignor or assignor, and that is you. So whichever entity you've signed that sale and purchase agreement in, that's the name you put in there. And the assignee, the assignee or nominee, is the buyer, this person who's about to purchase this property. Then goes on to say, by a certain agreement for sale and purchase dated, you put the date on the sale and purchase agreement, and then you put the legal description of the property, which you would copy straight off of the sale and purchase agreement. And then it talks about who's doing what. So what this document basically says is that under C there, the assignee, the buyer, agrees to indemnify you as the seller for any breach of the obligation, so they're assuming responsibility for the agreement. Your buyer's lawyer is responsible for making the agreement unconditional on the day that this agreement is done, and the buyer is going to pay the deposit that you've got in the original agreement. E there says that the finder's fee is to be paid immediately upon signing of this agreement. Then it goes down. The only other bit that you fill in is under number 3 there. It says that the assignee, which is your buyer, agrees that they'll pay a non-refundable finder's fee of X dollars, including GST. So when you both fill this out and sign it, they will give you a cheque for the finder's fee. And then under 6, that says that you will refund the fee if clear title cannot be obtained from the vendor. Alright, so you fill in there the amount. It's usually $5,000, but it can be anything. And then down the bottom here, not much point showing you, you fill in your name, you fill in your lawyer's name, your lawyer's phone number and your lawyer's fax number, and you get whoever's buying it, you get their name, and you get their lawyer's name and phone number and fax. And then on the bottom you fill in the vendor. So this is the person where you've got the conditional sale and purchase agreement. So off that agreement you fill in the vendor's lawyer's details, okay, name, phone and fax number. So you now have on this one piece of paper. The reason this is done like this is that you now, on one piece of paper, if you were doing a lot of assignments, or just one, but anyway, on this one piece of paper you now have the legal description of the property, the address, how much money they've paid, which they should have paid, and you've got all of the contact information that you need. All right, because what happens from here is that you need to make sure that your buyer pays the deposit and goes unconditional, and I would normally get my lawyer to contact the vendor's lawyer and say that the property, the agreement has been signed, give the vendor's lawyer a copy of this bit of paper, and then you just make sure that it gets to settlement and that it actually gets settled. So in terms of paperwork, there's just this, and there's the conditional sale and purchase agreement. All right, and so that's it. When you find your buyer, you fill in this, you then get them to sign it, you sign it, they pay the deposit to you, so then you've now got conditional S&P is done, the deed of assignment is done, and your buyer then takes over the conditional sale and purchase agreement. And they, just to cover it again, just so you're clear, they pay the deposit and they go, well, that pen's dying, and they go unconditional. And from that point on, your involvement is technically at an end, but in reality what you would do is you will just make sure, and when I was working with a finder when I was first learning this stuff, you sometimes have to be quite proactive with it and keep on top of it. Sometimes you don't, but you need to hound your buyer until they've paid the deposit and their lawyers declared the contract unconditional. Then you are technically out of the loop, but I would suggest that you just keep on top, ring the lawyers, get your lawyer to keep on top of things, and make sure that you actually get to settlement day. Your fee you should have got, don't wait till it settles, you want that when you hand over this document. Okay, when you sign this document and they sign it, that's when you get paid. It is non-refundable. You may get in a situation where ethically you feel you have to, that's obviously fine, but you just be aware that you're not under any obligation to, as long as you haven't done anything wrong and as long as clear title can be obtained. So that really is it for assignments. I'm just trying to think if there's anything else to really tell you. If there's anything else you'd like to know, please email me in the next 24 hours, and before I do tomorrow nights, I'll cover it. But I can't think of anything else you need to know. So this is just a lower risk way to get started, but I can't stress enough the fact that you need to be looking for a property that there's some reason why it's going to be easy to assign. You know, you don't want to be just going and signing anything up. And perhaps one of the best ways to start to learn this, there's not much paperwork, so it's not very involved, but is to help someone who's trying to buy a property, offer to go and negotiate it for them, and just go through the paperwork with a level of risk to you is effectively none. And as I've mentioned before, one alternative to doing it as an assignment is to actually split the difference between what they would have paid and what you can get it for, but that's a bit off topic. Alright, so I can't think of anything else to tell you. I hope that's been helpful. What we'll do tomorrow is we'll do double settlements. I'm quite happy to discuss anything. If I don't hear from anybody, I'll just go through the stuff that I can think of, but if there's anything you'd like me to cover, particularly just making sure you're clear on the paperwork and the actual nuts and bolts of how to get through the process, please email me and tell me, and I'll be very happy to oblige. Other than that, have a wonderful day. See you tomorrow.